Now, I'll be taking you through contract and I will be revising together. What is a contract? A contract is a legally binding agreement between two or more parties. It is a legally binding agreement between two or more parties where each party promises to do or not to do something in exchange for something else. It is a legally binding agreement between two or more parties where promises to do or not to do something in exchange for something else. This definition may, however, be suitable to standard form contracts which allow for little or no agreement. Under the American law, the concept of agreement is avoided. Under this law, a contract is a promise or set of promises for the breach of which the law gives a remedy or performance of which the law recognizes as a duty. Formally, the writers and court placed much emphasis on the need of meeting the minds of consensus ad idem for making such contracts and the consensus theory of contract. Consensus ad idem means meeting of minds where parties both where parties like meeting minds together, where they come together under one sense, under one critical thing together, they agree on the same thing in the sense of mind. That's what we call consensus ad idem. And under the consensus theory, it is a sociological perspective that sees society as based on shared norms, values, and agreements. It emphasizes social order and stability. Law, rules, and contracts are seen as a reflection of what most people in society agree is right and fair. Think of it as we follow rules because we all agree they are for the good of society. Um, and this resilience on actual intention was an impression of the laissez-faire philosophy and a belief of unfettered freedom of contract, meaning under the laissez-faire theory, this first of all, laissez-faire theory, it is a French meaning, let's do or leave alone. And when you put unfettered, it means undisturbed. No, there is no. So putting all together, it means there is minimal government interference. And that laissez-faire theory, it is an economic and political philosophy that advocates minimal government interference in business and society. The idea is that free markets, competition, and individual initiative regulate themselves better than government control. So in simple terms, contract is a legal agreement. Consensus theory society works because people agree on shared values or rules. Laissez-faire theory, government should interfere as little as possible in people's economic activities. And I will also explain how these three uh, consensus theory, laissez theory, and contract, how they connect. Now, contract in law and society. First, let's go to contract in law and society. Contracts allow individuals for business to make agreements freely without needing governments to dictate every details. They are legal backbone of trade, work, loans, and even personal promises. Consensus theory link society accepts contracts as valid because people agree on the basis rules of fairness, keeping promises, honoring agreements. This shared belief in the importance of trust and obligation reflects consensus theory. Contracts only work if most people agree to respect them. Laissez-faire theory link philosophy mean in the laissez-faire system, the government does not heavily regulate markets. Instead, contract becomes the main way people organize their economic relations. For example, instead of the state fixing the wages, An employer and worker sign a work contract freely. The philosophy is let individuals bargain and agree with themselves. Yeah, yeah. So I hope you have understood. Uh, the subjective approach to making of contract has now largely abandoned through it has though it has influence in some rules. What matters today is not what meaning a party actually intended to convey by words or conduct, but what meaning a reasonable person in the other party's position will have understood him to be conveying. This is known as the process of objective interpretation. You can see the subjective approach of this making contrast. What matters is what the is not what the meaning the party actually intended to convey by words, but it is what a reasonable person in the other party position will have understood what that party is conveying. And that is what we are seeing this process is known as objective interpretation. What was the objective interpretation of the other party? That's why that's what matters in and however, despite the disappearance of the subjective approach, the law frequently refers to the intention of the party, even though we are still not looking of we don't want to today we don't want to know the meaning of what the party actually intended, but sometimes because that is a subjective approach, sometimes the law refers to the intention of what was the intention of that party when they drafted contract and as a test for resolving difficulties because there's some time where it is difficult to resolve the difficulties and this does not however refers to the party's actual intention which may well be conflicting but to the proper inference to be drawn from the facts as a whole. When deciding the proper inference, the judge has considerable room for maneuver and is in reality reaching a conclusion based upon the justice of which the case as much as upon any inference in strict sense. Let's look at the case of Oscar Chase versus William of 1957, which is also referred in other cases you can look at for yourself, where mm, you can look for yourself for the case of Oscar Chase versus William. Now, that case it is of a famous English contract case about misinterpretation and contractual terms. Now, Mr. Williams, who was the defendant, traded his Morris car with Oscar Chase Limited, a car dealer. Oscar Chase was a car dealer, and William was the one who was selling, and yeah, Mr. Williams was the one who was selling, and Mr. Williams stated in good faith that his car was a 1948 model based on the registration document. Later, it turned out that the car was actually a 1939 model, much less valuable. Oscar Chase Limited sued, claiming that this statement was a term of contract and not just an innocent misinterpretation. So the issue here was Mr. Williams' statement about the model year a binding term of contract, so Oscar Chase could claim damages, or merely a representation which would only allow rescission in fraudulence if fraudulent or negligent. So the judge, the Court of Appeal, the then judge was Lord Denning, presiding held that the statement was a contractual term but not a representation, was not a contractual term but only a representation. It was not a contractual term but only a representation. Why? Because Oscar Chase Limited, the car dealer, was in a better position of knowledge than Mr. Williams. Was in a better position than Mr. Williams, who was an ordinary person relying on the logbook. Williams did not intend to guarantee the model year as part of the contract. He was just passing an information, so it was not part in the contract. He was just passing on information according to the logbook. He was just a normal person, unlike Oscar Chase, who was a car dealer. He was in a better position to know when he was buying that car. He was in a better position to know the model of that car than the plaintiff, who is than the defendant, who is Mr. Williams. So whether a statement is a term or a representation depends on the intention of the parties, judged objectively. So here the factors were specific knowledge or skill. If the person making the statement has expert knowledge, it is more likely a term. If the person making the statement has expert knowledge, let's say here it was the other way around. Mr. Oscar here had special knowledge or skill to know the price, the date of year of that car. Reliance. If another factor is reliance. If the other party relied heavily on the statement, it may be treated as a term. That party relied, but they did not rely most. It was just a. So in this case, the car dealer was the expert, not Mr. Williams. So Oscar Chase Limited versus Williams, 1957, shows that not every statement in negotiation becomes a binding term. Court outlook at intention, expertise, and reliance. There's also an opposite case for this case for Mr. Williams and versus Oscar Chase. There's in the case of Oscar Chase versus William, we look who had knowledge. The car dealer, Oscar Chase, not Williams. What was said? William, the private seller, said that the car was a 1948 model, but it was a 1939. So the court overview was statement was a representation, not a contractual term. Reason being, William was just an ordinary seller relying on the logbook. He wasn't an expert. The dealer, Oscar Chase, had more expertise and should have checked. And now, this case, they often taught together with this case law. There's another case law for the opposite now, for Dick Bentley Production Limited versus Harold Smith Motors Limited, case of 1965. So in this case, who had knowledge? In this case, the person who had knowledge, it was the car dealer, Harold Smith, not Dick. What was said? The dealer told Bentley that a Bentley car had done only 20,000 miles since replacement of the engine and gearbox. In fact, it had done much more. So court view statement was a contractual term, not just a representation. Reason being, the dealer was an expert in the better position of knowledge. Bentley relied on the skill and judgment of the car dealer, the Harold. So the key differences between the two cases: in Oscar's case, the private seller made the statement less knowledgeable, so it was just a representation. And in Dick Bentley, the dealer made the statement. The dealer was Aaron, made the statement more knowledgeable, so it was a term. So, whether a statement is a term or a representation depends on who had special knowledge or expertise, whether the other party reasonably relied on that expertise. So, in these cases, it illustrates that balance of knowledge and reliance is crucial in deciding if a case becomes binding or contractual. Yeah. Now we'll ask ourselves, why are contracts enforced? Enforcement of contracts is associated with a moral notion that one should keep one's promises. Enforcement of contracts is associated with the moral notion that one should keep one's promises, a term that we say in Latin called pacta sunt servanda, to keep one's promises. In the 19th century, contracts came to be associated with particular type of political economic system, the free market or free enterprises system, which glorifies the freedom of the individual. I will read all that one. So will come. So one of the reasons why contracts are enforced is to protect promises. So contracts create binding promises between people or businesses. Enforcement ensures people keep their word, otherwise agreement will be meaningless. 2. To provide certainty and predictability. In business, employment and daily life, people need to know their agreement, and the people need to know that the agreement will be honored by law. This certainty allows trade, investment, and long-term planning. To prevent unfairness, that is number 3, to prevent unfairness, if one party fails to perform, the other might suffer. Enforcement ensures that the injured party can get compensation for specific performance. To maintain social and economic orders, and the fifth one, consensus injustice principle. So, in short, contracts are enforced because they protect trust, promote fairness, promote certainty and predictability, support economic and social stability. Now, we go to the sources of contract law. In Kenya, prior to the adaptation of contract law in Kenya, there was some customary contract based on the exchange of goods and barter. Many customary law did not regard this mere exchange of promises as always giving rise to legally enforceable agreements. In English law, on the other hand, the mere exchange of promises can give rise to a binding contract. In certain Kenyan community, a contract could even be unmade after it has been completed. Issues of fairness and unfairness were seen very important to the contract. So, replacement of African customary law contract in the pre-independence day with the English law of contract was regarded as necessary for development. With the passing of the Law of Contract Act in 1960, the question as to whether customary contract law was still existent became quite important. The Magistrate Courts Act make sure. So the Magistrate Courts Act makes clear that magistrates have no jurisdiction to apply customary law of contracts under Section 2. The question is whether the list is exhaustive exhaustive. Yeah, and in the one of the sources of the contract law in Kenya, it is the Constitution of Kenya, 2010. And this the supreme law. All contract law must align with the Constitution principle and fundamental rights like freedom of contract, fair hearing, influence, honor courts, and interpret contracts. We have also statutory law, common law and equity, and judicial precedent, customary law and African tradition, international law and convention. So we have the constitution, statutes, common law and equity, judicial precedents, customary law, and international law. So that's for today. We'll continue the rest tomorrow.